Good morning, my name is Hilman, and today my group and I will be comparing the approaches of the English and Malaysian law of contract towards the doctrine of duress as a vitiating factor. When talking about the doctrine of duress, we need to understand what exactly duress is. To put it simply, duress has been defined by Tritel, 13th edition, as when the consent of the contracting party or contract party may have been obtained through a form of pressure which the law regards as improper. This includes both physical and mental pressure. This can be called the overborne will theory, since the victim's will was overborne by duress when entering the contract. An example of this can be seen in the case of Barton and Armstrong 1976, where the former chairman threatened the managing director with death if he did not purchase the former's shares in the company. The Privy Council held that if the director's actions were a result from the chairman's threats, then the contract was made void. This shows that if there were no other factors besides there being the fear of threat when entering the contract, the court can hold that the entire agreement would be made voidable. Another theory as to why duress can make a contract voidable can be, although the victim might consent to entering the contract, he or she would only do so because there was the factor of there being improper pressure placed upon them by the other party. This can be called the illegitimate pressure theory. An example of this can be seen in the case of R and H.M. Attorney General for England and Wales 2003, where the case involves an SAS member who was a party to a specific patrol who was considered infamous due to the amount of controversy surrounding their actions. In light of this, the Ministry of Defence forced all members of the patrol to sign confidentiality agreements. The members in question refused to do so, and the Ministry of Defence threatened him with a demotion to a less important unit. The member in the end signed the contract, but eventually claimed that he was forced to sign it under duress. The court explained that some demands may be lawful, but would constitute duress. However, if the demand is justified, the pressure would not amount to duress. In this case, the threat of demotion amounted to legitimate pressure in light of the importance of how confidential the agreement was. The member in question still had a choice. He could have taken the demotion in order to opt out of confidentiality. The court described the pressure as overwhelming but not illegitimate. Thus, the claim failed. There are three types of duress which my groupmates will soon be explaining. These are duress to goods, duress to persons, and economic duress. Now we'll talk about the effect of duress, which basically means the choice available to a victim of duress. They are 1. The choice to affirm, or in other words continue with, the contract. 2. Resign, also known as terminate the contract. And 3. If they get sued as a result of breaching the contract, use duress as a defense. Since duress operates to prevent the will of the party and not obtain their consent, the effect of finding duress would be on making the contract voidable and not void, since the party under duress would have already entered the agreement, albeit not under own free will. In English contract law, if the party is able to prove that they were coerced into a contract due to a threat of violence, the contract would be voidable. There are two main requirements of duress by threat of violence. 1. The nature of the threat must be sufficient to amount to duress. The threat must be sufficient in its nature to amount to duress, usually the indicator that the courts have used is whether the threat is illegal or not. And 2. The effect of the threat must have been that it forced the claimant into the contract. The distinction to make when asserting the effect of the threat is whether there is a threat which results in a claimant voluntarily entering the contract, or whether the claimant involuntarily entered the contract. This can be seen in the case of Northern Ireland and Lynch 1975, where the defendant was charged with aiding and abetting a second-degree murder. He drove members of the Irish terrorist group, the IRA, into town where they had shot and killed the police officer. At the trial, the defendant claimed that he was under duress and was threatened that if he did not drive the members, he would be killed. His defense was struck out, so he appealed. It was held that the appeal was allowed and the defendant was able to rely on duress as a defense to aid in murder. In Malaysian case law, The Contracts Act 1950 calls duress as coercion, which Section 15 defines as committing or threatening to commit an act forbidden by the Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatsoever with the intention of causing any person to enter into an agreement. When under effects of duress or coercion, we must refer to Section 19, subsection 1 of the Contracts Act 1950, which states that when consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. This means that similar to English contract law, the party under duress or coercion is able to and has the option to make the contract voidable so long as they prove that they had only entered the contract solely due to coercion and no other factors affecting their choice.
My name is Mariam Raita Ibrahim, and I am here to talk about duress to a person. Duress to a person arises when there is actual violence or threatened violence against a party or to a family member of a party to a contract. Duress to a person is established in English law on common law principles in the Privy Council case of Barton v. Armstrong. In this case, the House of Lords held that the contract was voidable even though the contract was signed predominantly out of commercial necessity, and it was immaterial that the duress was not the sole reason for entering into the contract. The two elements necessary to succeed in bringing a claim on the grounds of duress to a person are established in this case. First, the claimant must show illegitimate means such as fraud, undue influence, duress, or coercion were used in influencing him into entering into a contract. Secondly, the claimant must show a causal link between the alleged duress and entry into the contract asked to be rescinded. It is not a requisite that the threat is the sole cause for entry into contract. It is sufficient to show duress was a factor in influencing entry into the contract. In Malaysia, overborne wealth theory plays an important role in contracts. This is supported by Section 10, subsection 1, Section 13, Section 14A of Contracts Act 1950, which is based on the freedom of contract doctrine adopted from the Indian law. In contrast, English law puts a greater emphasis on the acts of the guilty party rather than the validity of innocent parties' consent, also known as illegitimate pressure theory. Although there is free consent in duress cases, however, it is not free consent as it has been affected by acts of coercion. When there is no free consent, the agreement is voidable at the option of the party whose will has been infringed. In Malaysia, duress to a person has been established in common law similar to the English method, but unlike the English law, duress to a person is supported through legislation by the Contracts Act 1915. Section 15 of this Act establishes duress to a person under the umbrella of coercion. Coercion is defined as committing or threatening to commit any act forbidden by the Penal Code to the detriment of any person whatsoever with the intention of influencing others into entering into an agreement. From the definition, it is evident duress is broader in Malaysia as it covers all prohibited acts in the Penal Code, but it also limits the scope to just the criminal acts. This is a narrow concept as it excludes tortious wrongs or threats, unlike the English common law duress. As Section 15 does not expressly mention the persons committing coercive acts must be a party to the contract, it is possible that a third party, coercion, may cause an agreement to be voidable. This is unlike the English common law duress, which is restricted to parties to a contract. Prejudice of any person in Section 15, such as coercion, must be detrimental to the innocent party. Therefore, it is an indication that substantive unfairness is a necessary component in duress. This is contrary to the English position, which focuses on the procedural unfairness when considering duress. They consider the unfairness of terms of a contract irrelevant when considering a contract influenced by duress. The third element of coercion under Malaysian law is the element of intention. There must be an indication. The third element of coercion under Malaysian law is the element of intention. There must be an intention of inducing the party into entering into a contract. This may be difficult to prove in civil cases. The element of intention is unnecessary to English common law duress. Causation is sufficient for recession. The innocent party induced into a contract is entitled to remedy under common law duress and equitable rules of undue influence similar to the English law.
Hi, my name is Safina Eunice Stevenson. Today I'll be speaking about duress to goods. Duress to goods is when a contract is entered into as a result of actual or threatened violence or illegal seizure of goods or other property. This can be set aside on grounds of duress. According to Vintage Navigation's case, the view that unlawful violence to the person was necessary to constitute duress has led a number of 19th century cases to be in the conclusion that contract can be invalidated by duress of good. The traditional position of the common law states that, firstly, it is insufficient to render an agreement to make payment voidable for duress if the threats are in relation to the goods, meaning an agreement to pay money for the release of goods unlawfully detained or to prevent unlawful seizure was valid. This was held in the case of Skate against Braid. In Ashley against Reynolds, it states, however, that money that was paid under an agreement reached by duress to goods could be recovered back. The effect was not wholly clear. It could have hardly meant that whoever successfully sued for money which he had agreed to pay for the release of his goods could then recover back what he had been compelled to pay in the first place. This simply means that money that has been paid for the release of goods can be recovered. However, the money to be paid under an agreement for the release of goods could be sued for, but if money is paid, it cannot be recovered back. In a later case, in 1866, shows inconsistency, where money paid under such agreement was able to be recovered back, as the only question that was discussed when deciding the case is if the detention was lawful. Recent authorities supports the view that duress of goods now depends on a modern and flexible test of duress, so that the question in each case is if there has been cohesion of will, as stated in the case of Pao On against Liao Yuliang, and if the test governs both the validity of the contract and also the right to recover back the money paid under it. The rule that money paid under duress can be recovered back also applies for where an unlawful charge is levied by unlawful threats. For example, if a courier refuses to carry goods unless he is paid more than he is legally entitled to pay. However, if there is no threats other than threat to make legal proceedings, when he demands the money, then the rule does not apply. The case that sets as a precedent that overruled the traditional position is the Sibion's case, where Justice Kerr stated that if I should be compelled to sign a contract under an imminent threat of having my house burned down or a valuable picture slashed through without any threat of physical violence to anyone, I do not think that the law should uphold the agreement. In simpler words, if someone threatens to destroy something valuable to you, then there's duress. In Malaysia, under Section 15, it covers the unlawful detention of property, and under Section 73 of the Contract Act 1950, where it provides liability of a person whom money is paid or anything delivered by corporation or even mistake must repay or return it. In Chim Nambi Development Sdn Bhd against Tai Kim Chu, Justice Yusof Chin stated that the definition in Section 15 should only apply for the purpose contained in Section 14, but does not apply in Section 73 of the Act. The word coercion in the context of Section 73 should be given its ordinary and general meaning, since there is nothing under Section 15 that says the word coercion should have the same meaning throughout the Act. In this case, respondents purchased certain houses to be constructed by the appellants and was asked to pay additional sum of 4,000 ringgit each to the applicants under threat, and the applicants were under threat to cancel their bookings for their houses. The applicant's main ground of appeal was that the respondents paid the sum voluntarily and was not under coercion. The respondents claimed for a refund for the additional sum that was paid under Section 73 and succeeded. Thus, it can be seen that coercion is prohibited under Contracts Act 1950, which covers the unlawful detention of property and does not have the same stand in common law, as common law only used to recognize actual or threatened violence to persons. Meanwhile, threat to property did not amount to duress. However, as time passed, the English court has recognized that Doctrine of Duress should not be limited. Thank you.
Economic duress was a late addition to the English law, as this doctrine showed further developments by Justice Kerr in the case of Occidental Worldwide Investment Corporation and Skips Evi Avanti, which is also known as the Sibowen and the Sibotre case. Even though this case was decided as an ordinary commercial pressure, the issue of economic duress was mentioned because it was argued that economic duress may occur when there are threats from the other party before breach of contract takes place. The case of North Ocean Shipping and Hyundai Corporations, which is recognized by the courts as the Atlantic Baron case, further enforces the existence of economic duress. The decision of this case was such that the essence of duress is the compulsion of the will, and that duress can exist when there are threats by physical violence. This case was a significant case when it comes to economic duress because Justice Mokata made 3 points before reaching a decision, namely, recovering a certain amount of money paid under duress does not mean duress to goods. Second, a threat to break a contract may constitute economic duress, and that such contract will be a voidable contract. Furthermore, this case explains that there must be consideration for a party to alter its contractual obligations in exchange for something of the same value. It is also worth noting that when the requirement is not achieved, a party that does something they are already bound to is not providing a fresh value to the existing contract, thus concluding that renegotiation is not binding. However, the case of Williams and Roffey Bros gives light to a different point of view where consideration is possible when there are practical benefits between the involved parties, even though a party did not go over its contractual obligations. Thus, the courts have accepted this case as economic duress because it was flexible and it was closer to modern commercial practice where fluidity is a necessity to consider a constantly evolving market condition. As for the Malaysian law, coercion under Section 15 of the Contracts Act 1950 is equivalent to the common law of economic duress. However, there have been conflicting views on whether Section 50 covers economic duress, because VC Justice George acknowledged the lack of information on other forms of coercion in Contracts Act 1950. Coercion is defined as committing any forbidden act listed under the Penal Code Act 574 with the intention to force the other party to enter into a contract. It is of utmost importance to note that the Malaysian law embraces a broad spectrum of duress because Section 50 covers all of the act listed under the Penal Code. The courts took notice of economic duress as a vitiating factor in the case of Tech 1 Trading and Hydrotech Engineering. It was held that there was no coercion under Section 15 because the offense committed by the plaintiff to refuse to lower the price of the supply of goods did not amount to unlawful detention. The courts also decided that there was no economic duress because this was an ordinary transaction between the parties and that the agreement to a price was a demonstration of free will. Coercion is also mentioned under Section 73 of the Contracts Act 1950, and the case of Wong Ah Fook and the state of Johor raises the issue whether Section 73 conveys a different meaning from Section 50. The case was decided as such that Section 73 only deals with issues that does not have to do with contract. Thus, the courts were able to make a distinction between the two acts. It is obvious that the common law and the Malaysian law defines duress similarly. However, it is important to note that each position interprets certain points of duress differently due to each of the judges' different points of view. And this shows in the different decisions reached in all cases under duress for both law positions. Therefore, different approaches made by different judges may be beneficial for the courts to narrow down the judgment for future cases.